Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled, Does Trademarking Your Name Stop Child Support Enforcement? But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, I would like for you all to hit that like button, and also, if you're new to my channel, hit that subscribe button, and also hit that notification bell so you all can be notified as I'm dropping these powerful videos. So without further ado, let's get to it. Okay, so the reason why I'm touching on this subject is because there's individuals that's teaching that if you have your name trademarked, then you can file proof of that trademark into the child support enforcement case, and it will prevent the child support enforcement agency and the court from proceeding forward, and the court will simply dismiss the case against you, okay? And the logic behind this is they believe that by filing a trademark proof or trademark certificate into the case, then that shows or that will be used as evidence to separate the living, breathing man from the legal entity, aka the straw man. All right. So now, as you all can see on the screen, this is an exact replica of what you will receive from the United States Patent and Trademark Office if you was to trademark your legal name. Okay. So now it states what? United States of America, United States Patent and Trademark Office. Highlighted in yellow, guys, where it states trademark. That's where they will have you state your legal name. So where it states tricks of the trademark, you will put your legal name right there in all caps. So let's say if your legal name is John Doe, you will put John Doe right there in all caps. That's what they will have you all do, right? But where it states owner, you will put John Doe in upper and lowercase, just like it is on the screen where it states Erg and Pelton in upper and lowercase. And then in the brackets or in parentheses where it states Virginia Professional Limited Liability Company, you would just put a living, breathing man right there, right? And whatever address you're using for the trademark, all right? Where it states class 9 is to represent what? Highlighted in yellow, it states description of goods and services. So now let's read class 9. Let's see what types of goods and services that this business will be, or this trademark will be used for. And the goods and services is what? Downloadable podcasts in the field of law, intellectual property, marketing, brands, and trademarks. Okay? But again, the key words are what? Descriptions of goods and services. So for those who have watched my video pertaining to child support and the Fair Debt Collectors Practices Act, we found out that the Fair Debt Collection Practices Act does not apply to child support. Why? Because the Fair Debt Collection Practices Act deals with what? Consumer law, which is what? Goods and services. The same thing with the trademark. The trademark is dealing with what? Consumer law, which is goods and services. So that alone automatically makes this document null and void pertaining to child support cases, okay? So that's why I tell you all to watch out to where you get your information from, because a lot of people, they're just finding stuff into their case trying to see what sticks. But then they get mad and wonder why the judge calls their documents goop gobbledygook. That's because they don't have a clue of what they're doing, guys. Okay? Also, it states below, first use, they will have you put your date of birth there, and first use in commerce, they will still have you put your date of birth there. Why? Because they want to make it seem as though the living man has been using that trademark since the date of his conception, okay? Or her conception, all right? Then it states what? The mark consists of standard characters without claim to any particular font style, size, or color, right? Then it's what? Highlighted in yellow, application filing date. So once you file one of these, you will also receive a filing date and a serial number. And also the registration date is the date that it was registered, and the registration number, which you all can use to search up your trademark, okay? But let's continue on. At the bottom, it has the United States Patent and Trademark Office seal, right? As you all can see. So the document will look exactly the same, all right? So now that we went over a trademark certificate within itself, let's go over the importance of an owner of the trademark. Let's see what a trademark owner is, all right? So let's go there. All right, so now as you all can see, we're coming from Cornell Law School. Let's go over trademark owner, right? And it reads, trademark owner is the party who controls the nature and quality of the goods and services used in connection with the brand. The owner of a trademark is what? The person, we all know what a person is, but let's continue on, who applies the mark to goods that they produce or uses the mark in the sale or advertising of services that they perform. A trademark owner can include, but is not limited to, individuals, partnerships, corporations, limited liability companies, sole proprietorships, trust, estates, etc. All of those guys are legal terms that pertain to what? Legal entities, okay? But again, as it states, right? It's dealing with what? Goods and services. All right, as we stated again in the Fair Debt Collectors Practices Act video. Let's continue on. It states what? The owner of a trademark may pursue legal actions against trademark infringement. So we're going to see what trademark infringement is, just in case, individuals think that because the Child Support Enforcement Agency used that mark or they wrote your name on a document, then you can try to sue them for trademark infringement. Let's see if that's even possible, guys, okay? So now, let's click on trademark infringement. Okay, so now let's go over trademark infringement for those who believe that because you have your name trademark, if anyone uses it, such as a judge, and he writes an order in that name, and you get mad if you want to sue him or the agency, we're going to see if you have any standing at all. So now let's read trademark infringement. Let's see. It states, trademark law protects a trademark owner's exclusive right to use a trademark when use of the mark by another would be likely to cause what, guys? Consumer confusion. Again, we're dealing with consumer law here, guys. As I stated in my video pertaining to the Fair Debt Collectors Practices Act. Just like child support does not fall into the Fair Debt Collectors Practices Act that's dealing with consumer law, neither does they fall underneath the trademark law, because guess what? They're still not dealing with consumer law. All right? Child support, again, is a common commercial, common civil debt. It is not a consumer debt. Okay? They are not selling goods and services. Let's continue on. Then it states, as to the source or origin of goods, as you all can see. Then it states, trademark law is a federal issue, and as such, the Laham and MBSP Act is the federal statute which governs trademarks. To establish a violation under the Laham Act for either a registered mark under 15 U.S.C. subsection 1114 or an unregistered mark under 15 U.S.C. subsection 1125A, the plaintiff must demonstrate that what? 1. It has a valid and legal protectable mark, and 2. It owns the mark, and 3. The defendant used the mark to identify what? Goods or services, right? Causes a likelihood of what? Confusion. So what child support is offering compared to what a trademark is offering, such as goods and services, is two totally separate things, guys. And because it's two totally separate things, you cannot sue the agency even if they did use the name. Even though you have a trademark and they decide to use the name, you cannot sue them. Why? Because they are not underneath what? Consumer law. So this trademark again will not work. And we're going to go over case law to prove that as well. But let's continue on. It states what? To prevail on a claim of trademark infringement, a plaintiff must establish that it has a valid mark entitled to protection and that the defendant used the same or a similar mark in commerce in connection with the sale or what? Advertisement of goods or services without the plaintiff's consent. So again, guys, you have to show that they participated in commerce basically on the consumer side or consumer law side, dealing with goods and services. Okay, again, as stated in my Fair Debt Collectors Practices Act video, we know that child support does not deal with goods and services. So just like the Fair Debt Collectors Practices Act does not apply to child support, neither does the trademark infringement. But let's continue on. The plaintiff must also show that the defendant what? Use of the mark is likely to what? Cause confusion as to what? The affiliation, connection, or association of the defendant with plaintiff, or as to the origin, sponsorship, or approval of the defendant's goods, services, or commercial activity by the plaintiff. So, in order for the plaintiff to have some type of suit to try to sue for infringement on the trademark, the defendant must be using that name and doing the same business that the owner of the trademark is using. So that's basically me coming out with a McDonald's, and there's already a McDonald's out there, but I'm using McDonald's name, but I'm not selling McDonald's food. I'm still in the food business, but I call my company McDonald's. No, I can get sued like that. Why? Because I'm in foods and services, and because I'm in foods and services, and McDonald's in foods and services, then McDonald's can sue me for what? Trade name infringement. And child support, if you're not in child support services and you're not providing child support services, and they are providing child support services, it's two different types of services. So you can't even sue them on that as well. Let's continue. Thus, use in commerce and likelihood of confusion are three distinct elements necessary to establish a trademark infringement claim. And it's just that simple, guys. But now let's go back to trademark owner. Let's go back there. Okay, we're right back at trademark owner, but let's go back down to where we left off at. And it reads, very top line, the owner of a trademark may pursue legal actions against trademark infringement. Most countries require formal registration of a trademark as a precondition for pursuing an action for trademark infringement. However, the U.S. recognized common law trademark rights, which means actions can be taken to protect any unregistered trademark if it is in use. Federal registration is not a prerequisite of trademark ownership, but it offers the trademark owner certain benefits, a legal presumption that you own the trademark and have the right to use it. Okay? But that's it for that. So now let's go to case law also, just proving, guys, that, again, like we did in the Fair Debt Collection Practices Act, let's just further prove that child support does not deal with commercial law. Let's continue on. Okay, so now we're coming from Sykes versus the Bank of America, which is a Court of Appeals case from the Second Circuit from 2013, okay? Now it states what? Derry Sykes, who is the plaintiff, versus the Bank of America, New York City Human Resources Administration, Office of Child Support Enforcement, defendant/appellees, State of New York State Child Support Processing Center are the defendants, as you all can see. But now let's get straight to the meat and potatoes, okay? All right, the background right here. Let's pick this up right here, guys, where it states, moreover, very top. All right, it states, moreover, according to the court, even if Sykes has established that his SSI benefits were not subject to levy to satisfy an outstanding child support obligation, any challenge to a state court child support order had to be dismissed pursuant to the domestic relations exceptions to federal court jurisdiction. See case law right there, and then it states what? And the Rooker-Feldman Doctrine. See also ExxonMobil, which is also a case law. Then it states the vesting federal courts of jurisdiction to consider suits which seek to overturn a state court judgment. The district court also determined that Sykes had failed to allege a claim under the Fair Debt Collection Practices Act because child support obligations did not qualify as what? Debts under the statute, as I stated before, right? But let's continue on. The court reasoned that child support obligations were not incurred to receive what? Consumer goods or services, right? As I stated, but were imposed on parents to force them to what? To fulfill their duty to support their child. As I was telling you guys, child support is a legal duty. And it's just that simple, okay? So this is just more facts, more proof, more truth, guys. Be careful who you all listening to, man. Like I tell you guys, there's individuals on YouTube that's trying to teach you guys how to get off of child support, who are on child support themselves, and they're having a hard time, so they're just throwing stuff in their case to try to see what sticks. But they're basically stuck until they find out the proper way of moving, okay? But look, that's what I'm going to do for today. If you all need my help, hit me up in my email at y'allismagnified@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. And with that being said, you all be blessed, and I say shalom.